Today we are going to discuss a very important topic is that salient features of Indian Constitution. You know very well in our examination point of view, this is the very frequent one. It consists 10 marks one. It undercomes 10 marks one as essay. You have to pay the attention on this one. Let us try to understand step by step. So before going to details, let us just brief about the introduction of Indian Constitution. You know very well the Constitution of India is very best constitution among the world constitutions. It was formulated by Constituent Assembly, adopted on the date of November 26, 1949 by Constituent Assembly, and it was came into force in the year 1950, January 26th. So that is why you have to remember these two important dates regarding to the Constitution of India. Our Constitution of India formulated by the Constituent Assembly and approved by Constituent Assembly on the date of November 26, 1949, and it was enforced on the date of Jan 26, 1950. You know that at the time of Constitution of India was enacted, the Constitution consists 395 articles, 8 schedules and 22 parts. So that's why after the enforcement of the Constitution, the articles and the parts schedules are increased. At present they are around 486 articles are there, and 12 schedules are there, and 24 parts also there. That's why you have to compare. At the time of enactment of the Constitution there are 395 articles. Now there are 486 articles. At the time of enactment of the Constitution there are 8 schedules. At present there are 12 schedules. And parts 22 they increased as 24. For making our Constitution, the Constituent Assembly formulated 22 committees. 22 committees. In that very important is that drafting committee. Drafting committee. You know very well, drafting committee chaired by Dr. B.R. Ambedkar. Dr. B.R. Ambedkar. Dr. B.R. Ambedkar is popularly known as Father of Indian Constitution. M.V. Filey said that Dr. B.R. Ambedkar as Father of Indian Constitution. He was the chief architect of the Indian Constitution. So along with Dr. B.R. Ambedkar, there are 6 other members in drafting committee. Okay. So here, for making of the Constitution, the Constituent Assembly took 2 years, 11 months, 18 days. 18 days. You have to note it down. For making of Indian Constitution, the Constituent Assembly took 2 years, 11 months, 18 days. According to the Ivor Jennings, the Constitution of India is best among the all constitution in modern governments. That's why you have to mention the brief introduction about the Constitution of India before going to write the salient features of Indian Constitution. Why we are going to discuss about salient features here? While making our Constitution of India, we approached around 60 constitutions. Around 60 constitutions for best features. And we borrowed so many features from the 60 around world constitutions and incorporated in our Constitution. That's why some are criticized as Indian Constitution patchwork, Xerox copy. Whereas Dr. B.R. Ambedkar said it was not patchwork, it was not Xerox copy, because we followed the 60 constitutions and they they adapted to the Indian constitution according to the Indian environment, Indian customs and traditions, Indian practice. That's why here Indian constitution is the best among the world constitution according to the Ivor Jennings. Let's go with salient features of Indian constitution one by one. The very first is that it is the written, detailed and lengthiest constitution in the world. You know very well, Indian constitution is the written constitution, detailed constitution, detailed constitution. You have to mention the factual information in this. Actually, you have to compare with other constitutions. Indian constitution is the written constitution. You know very well, the constitutions are classified into two types based on the nature. Because here the constitutions are, some are unwritten manner, some are written manner. If the constitution which is in written manner, that was the written constitution. The constitution which is in written form is called as written constitutions, whereas the constitution which is in unwritten form, unwritten manner, is called as unwritten constitution. Give the example here. Unwritten constitution, very popular constitution is that Britain constitution. Britain constitution, whereas rest of the Britain remaining constitutions mostly written constitution. That's why the popular examples of the written constitution is that USA constitution, Indian constitution, Canada constitution, Australian constitution, even China constitution also. They are the examples of written constitution. Here Indian constitution was a written document, you know very well. So because we drafted the constitution, for making the constitution, for drafting the constitution, we formulated drafting committee. This committee drafted the constitution, which consists 395 articles. Just now we discussed 395 articles and 8 schedules and 22 parts. At the beginning of the Indian constitution, the constitution consists 395 articles, 8 schedules, 22 parts. Now they are increased as 486 articles, 12 schedules, 24 parts. 24 parts. You have to compare with other constitution. If you take example as USA constitution, it consists of 7 articles. 7 articles. If you take Australian constitution, it consists of 128 articles. If you take China constitution, it consists of 138 articles. 138 articles. If you take Canada as example, the Canadian constitution consists 147 articles. So now compare with Indian constitution. So USA constitution, which consists 7 articles. Australian constitution, which consists 128 articles. And the China 138, Canada 147, the lengthiest among the world constitutions. Understood? That's why you have to compare like comparative manner while you are making the answers. Understood? That's why here Indian constitution is the written one and the lengthiest one, and moreover why this was became bulky and lengthy, because of the incorporation of all the provisions in very detailed manner. What are all the provisions regarding to the rights, responsibilities and the directive principles, and the bifurcation of the powers between the legislature, executive, judiciary. Like this, they incorporated all the provisions in the Indian constitution in very clear manner about the elections, about the rights, duties, and also directive principles of state policy, and also mentioned clearly about the parliamentary provisions, legislative provisions, relation between the union government and the state government, And all those things are clearly mentioned in our constitution. That's why it became bulky. Became bulky. You have to mention Indian constitution is the written, detailed and lengthiest constitution in the world constitution. This is the picture. So is it yes or no? So this is the one. This is considered as the first salient feature of the Indian constitution. So what is meant by salient constitution? Salient feature here, the feature which is alone enjoyed the Indian constitution, because there are some features enjoyed by other constitution. Here our constitution enjoyed some specific, some peculiar features. They are called salient features, basic features of Indian constitution. Clear, I thought, all of you. Then the next one is that India is sovereign, socialist, secular, democratic republic. India is socialist, secular, democratic republic. The second salient feature is that India is sovereign, socialist, secular, democratic and republic. So India is sovereign, socialist, secular, democratic republic. It is also one of the salient feature of Indian constitution, which mentioned in our preamble. You know very well, our preamble is the preface of the Indian constitution. In the preamble, we clearly mention, we the people of India, having solemnly resolved India into a sovereign, socialist, secular, democratic republic. Yes or no? So what it means? India is sovereign country. India is the socialist country. India is the secular country. India is the democratic country. India is the republic country. It is the nature of the Indian nation. That's why we have to mention one line at least for each and every word which are mentioned in our preamble clearly. So what is meant by sovereign here? The sovereignty means supreme power. Supreme power. You know very well, you studied in first year. Sovereignty means supreme power. This power vested with the India. So this supreme power enjoyed by the state of India, either internally and externally. That means the sovereignty is internal and external. Internally, India is enjoyed the supreme power on the people of India. Externally, the India enjoyed the supreme power on the other states. That means here, while taking any decision in India, Indian government or Indian state enjoyed the supreme power over the people of India. Then, if in external manner or external sovereignty point of view, our India enjoyed the freedom from abroad. Freedom from abroad. That means, while enjoying the internal sovereignty, it enjoyed the full command on the people. While enjoying the external sovereignty, it enjoyed the freedom from other countries abroad. So here, India is a sovereign country. India never obey the external burden or external obedience. That means, for example, in the year 1949, India took membership in the Commonwealth countries, Commonwealth nations. These are the nations which are under controlled by British colonial rule. That means the head of the Commonwealth nations are British Queen. So we took the membership in the Commonwealth nations. But here it was not reduced the supreme power of the Indian government. It is the extra constitutional decision made by the government of India for taking membership in Commonwealth nations. So being a member of the Commonwealth nations, we are not losing our sovereignty. At the same time, we also have the membership in UNO, United Nations Organization. In the year 1945, we took membership in United Nations Organization. Here also, we are not losing our sovereignty. We are enjoying the sovereignty in internal manner, at the same time external manner. So this is called sovereignty. India is the sovereign country. Is India considered as a sovereign state? Yes, India is considered as sovereign state. Then secular state. What is mean by secular state? Sorry, socialist state. The second term is that socialist. You know very well, beginning the constitution, that means in the original constitution, the socialist and the secular words are not existed. Later on, we added to the Indian constitution. We incorporated these two words to the preamble in the year 1946 by 42nd Constitutional Amendment Act. Understood all of you? Here, by the 42nd Constitutional Amendment Act, we added socialist secular terms to our preamble. Now the preamble is considered as India is sovereign country, socialist, secular, democratic republic. Before that, India is sovereign, democratic republic. That is the change after the 42nd Constitutional Amendment Act. So now, socialist country. You know that what is mean by socialist country, socialist state? In the socialist country, the state should take responsibility to provide economic, social and political welfare to the people of the country. Understood? The state should take responsibility to provide social justice, economic justice and political justice. So that is called socialistic nature of the state in Indian point of view. So before going to that, you have to remember there are two different dimensions of the socialist countries. One is, you know, that communist basis of the socialism, communist basis. Another one is democratic basis. That means communist socialism, which is influenced by Karl Marx, and democratic socialism, which is influenced by Gandhiji. Understood? So there are two different dimensions regarding to the socialist point of view or socialist nature of the state. One is influenced by Karl Marx, that was the communist point of view. Another one is influenced by Mahatma Gandhi, that was democratic point of view. Here the communist point of view, the country which nationalize all the forms of production, on the forms of production. That means nationalization of all the means of production. Nationalization of all the means of production. All the means of production. This is communist based of socialistic state, which is practiced in China, which is practiced in Russia. At the same time, abolition of private property, abolition of private property, abolition of private property. So these are included in communist basis of socialistic nature. Whereas in democratic point of view, we are not followed these nationalization of all the means of production and the abolition of private property in India. We adapted democratic form of socialism. Democratic form of socialism, which are influenced by Mahatma Gandhi. So what is mean by democratic form of socialism? Here we provide welfare to all people, that is, the state should responsible to provide welfare to the all people. That is called Gandhian style of socialism. So nothing but here Indian type of socialism, which is the bunch of Karl Marx and Gandhiji, which are influenced by both Karl Marx type and the Gandhian style of socialism. Clear all of you? Is India considered as a socialistic state? Yes, India is considered as socialistic state because here the India is taking responsibility to provide welfare to the people of India. So this is called socialist. India is the sovereign country. India is socialist country. Then what about secular? Is India secular state? Yes, India is secular state. So is socialistic word existed in original constitution? No, it was introduced in the year 1946 by 42nd Constitutional Amendment Act. So in original constitution, these two words are not existed because we are not expected this type of words in our constitution because we already mentioned one fundamental right, that is right to religion. What is that? Right to religion. So before incorporation of this socialistic word or secular word, we have some features regarding to such a nature of secular state, that is right to religion. You know that Article 25 to Article 25 to 28 25 to 28 of the Indian Constitution deals right to religion. You know very well, we studied in the fundamental rights. It is the very popular fundamental rights, that is the right to religion, Article 25 to 28. So before incorporation of secularism, we have the features of secular state in the concept of fundamental rights. Part 3 of Indian Constitution from Article 25 to 28 deals right to religion. So then what is mean by secularism here? The state which provide equal status to all the religions, irrespective of any religion. Here we are enjoying the equality in the matters of religion. That means no official religion of the state. That means India does not have any official religion. So all the religions are living together. At the same time, all the religions are treated equal manner. So there is no special privileges to any particular religion. So that is why here India is secular state. India secular state? Yes, India is secular state because there is no official religion of the India and all the religions are treated equal manner only. This is called secular. Then democratic or the democracy. You know that is India democratic state? Yes, India is democratic state. What is mean by democracy? The term democracy is derived from the two Greek words demos and krasia. What are they? Demos, krasia. Demos means people, krasia means rule. That means, hence the democracy means rule by people. Rule by people. It's a very popular definition given by Abraham Lincoln, you know very well. Democracy is the government of the people, by the people, for the people. Who gave this definition? Abraham Lincoln, former president of America. He gave very important and the popular definition is that democracy is the government of the people, by the people, for the people. Here, who are the kings in democracy? People are the kings in democracy. So here, India adopted democratic form of government instead of monarchy, instead of aristocracy. We formulated democratic form of government. Here, the democracy classified into two types of democracy. The one is direct democracy. Another one is indirect democracy. Understood? Democracy classified into two types. One is direct democracy. Another one is indirect democracy. If you take direct democracy, people who are directly participated in the government is called as direct democracy. Understood? The people who are directly involved in the government affairs is called as direct democracy. That means there is no medium between the people and government. That is called direct democracy. This type of democracy existed in Switzerland. Okay, so we found direct democracy in Switzerland. So keep it in mind, we studied all these in first years. Democracy classified into two types, direct democracy and indirect democracy. The direct democracy, which is directly involved the people, okay, by the four, very well, some devices which are regarding to the direct democracy: referendum, initiative, recall, plebiscite. You know that there are four devices of direct democracy. One is referendum, initiative, recall, plebiscite. By these devices, people are directly involved in the direct democracy. Whereas in indirect democracy, the people are indirectly participated in the government affairs. For example, between the people and the government, there are the representatives. There are representatives. Through their representatives, they are participated in that democracy. That's why this indirect democracy is called as representative form of democracy. Representative form of democracy. Representative democracy. Again, this democracy classified into two types. One is presidential form of government. Another one is parliamentary form of government. Presidential form of government which is existed in USA, and parliamentary form of government which is existed in Britain, India, like that. So this is about democracy. Then India is republic. India is republic. Is India republic or not? Yes, India is republic country, because while formulating the constitution of India, our constitutional makers observed so many options such as monarchy, at the same time republic. Basically, the democracy which is classified into two types. One is monarchy form of democracy and republic form of democracy. In this monarchy, the one head of the nation came from hereditary manner. Head of the nation came from hereditary manner. There is no election for the head of the nation in monarchy point of view. That's why we are not adapted such a hereditary manner of head of the nation, which is followed by the Britain. You know that Britain king or queen came from the hereditary manner. We are not taken for this India, and when we are adapted this from the France or French constitution regarding to the election. Our head of the nation came from election. So keep it in mind, our president of India came from election manner. That's why India is republic country. That means republic nation is nothing but the nation, the head of the nation came from the election manner, not hereditary manner. The head of the nation who came from election, who came by the election, not hereditary manner, is called as republic nation. That's why we concluded India is sovereign, India is the socialist, India is the secular, India is the democratic, India is republic country. The next one is that noble ideas, aims and objectives. Noble aims and objectives. The third essential element or the salient feature of Indian Constitution is that noble aims and objectives. Here, when you observe the preamble of Indian Constitution, we found the noble aims and objectives. So what are the noble aims and objectives? Firstly, the justice. Next, liberty. And third one is that equality, fraternity, and finally integrity. So these are the noble aims and objectives which are mentioned in our preamble of the Indian Constitution. Here, what is the justice? Justice on what matter? Justice on social justice or social manner, social justice, economic justice, political justice. Social justice, economic justice, political justice. Here, the state of India going to provide social justice to the all citizens of India to eradicate discrimination on the basis of religion, race, gender, caste, etc. etc. That's why here the state of India is responsible to eliminate discrimination among the people for providing social justice. And what about economic justice? Elimination of inequalities in the matters of minimum needs. Minimum needs. Minimum needs. Food, clothes, shelter. For providing food, clothes, shelter, India is responsible to provide food, clothes, shelter to the people of India. That means the India shall take responsibility to provide economic justice to the people of India. Then political justice. In the matters of participation in the government, India shall take steps towards providing equal opportunity in the matters of participation in the government. So this is called political justice. So like here, justice is the one noble aim and objective which are under social justice, economic justice, political justice. Then liberty. Liberty on what grounds? Liberty on 5 grounds. What are the liberty on 5 grounds here? Liberty of thought. Liberty of thought. Liberty of expression. Liberty of thought. Liberty of expression. Liberty of belief. Liberty of faith. Liberty of worship. Keep in mind, our Constitution of India, especially the Preamble of India, provide liberty to the people of India in the matters of thought, expression, belief, faith and worship. Understood? Liberty on 5 matters. So, regarding to the thought, the people enjoy the liberty, freedom. In the matters of expression also, the states provide freedom to the people of India regarding to the expression. Belief, faith, worship. So these are the noble aims and objectives under liberty. And what about equality? Equality on what matters? Equality in the matters of opportunity. Equality in the matters of opportunity. So here, equality in the matters of opportunity, equality in the matters of treatment. Understood? Equality in the 2 grounds. Equality in the matters of opportunity, equality in the matters of treatment shall provide by the state. That's why here the state of India shall provide equal opportunity to the people of India, equal treatment to the people of India. That means elimination of discrimination for providing equal opportunity to all citizens of the India as noble aim and objective. And fraternity. What is mean by fraternity? Fraternity is nothing but the brotherhoodness. What is that? Brotherhood. Fraternity means brotherhood. The state of India shall provide brotherhoodness among the people of India. You know very well, in the Constitution of India, Article 51A, under the fundamental duties, we provided brotherhoodness. That means the state shall promote brotherhoodness among the people of India. This is called fraternity. So it promotes the unity and integrity among the people of India. Fraternity, nothing but the brotherhoodness, promote unity and integrity among the people of India. So these are the noble aims and objectives of the Indian Constitution as salient feature. Then the next one is that the combination of rigidity and the flexibility. Combination of rigidity and the flexibility. Do you know very well? The constitution also classified in the manner of amendment procedure. The fourth salient feature is that combination of rigidity and flexibility. What is mean by rigidity and what is mean by flexibility? We studied in the first year. Flexibility. Constitution classified into two types on the manner of amendment procedure. One is rigid constitution. Another one is flexible constitution. The constitution which amended with special procedure. That means for the amendment of the constitution which is having special procedure, typically it was amended, is called as rigid constitution. The constitution which amend in typical manner. That means for the amendment of the constitution we have the special procedure that was called as rigid constitution. The best example of the rigid constitution is that USA Constitution, United States of America. It was the best example for the rigid constitution because American Constitution cannot amended easily. Whereas Indian Constitution, some parts of the Indian Constitution amended in rigid manner, some are amended in flexible manner. Here what is meant by flexible? Opposite of the rigid one. That means the constitutional provisions which are amended in simple manner. That means for the amendment of the constitution, if we have simple procedure, that was called as flexible constitution. Now, what is the example of the flexible constitution? Britain Constitution. Britain is the very flexible constitution in the world. What about the India? India is not the rigid constitution. India is not flexible one. India is the both rigid and flexible constitution. It is the blend of the rigidity and flexibility. Understood? It was the mixture of both the rigid features and flexible features. Then, according to the article 386, our Constitution of India prescribed three different methods to amend the Constitution of India. What are the methods? One is simple majority. That means 1/2 majority. And second one is that special majority. Which is 2/3 majority. 1/2 majority and 2/3 majority. And third one is that special majority with 50% of states ratification. 50% of states ratification. Keep in mind, all of you. There are the three different methods to amend the Indian Constitution. One is that simple majority, that is a 1/2 majority. That means 50% of the total member of the house, both the house of the Parliament of India. And special majority, 2/3 majority. 2/3 majority. Out of the three, 2% should be accept. And the third majority is that special majority plus 50% of states ratification. 50% of states should approve to amend some of the provisions. Here, what are the important provisions to amend the simple majority here? For example, creation of new states. For example, at the time of formulation of Telangana, we amended part 1 of the constitution under the article 3. Understood? So that was based on the simple majority, formation of the states, and also bifurcation of the boundaries of the states. That means adjustment of the changing of the boundaries of the state. It is also undercomes the simple majority. At the same time, creation of legislative councils, abolition of legislative council. They undercomes simple majority. Understood? Simple majority is the majority which require 1 by 2 majority. 1 by 2 majority in the separate houses separately. That means both the houses separately. Such example is that new state, creation of new states, and also abolition of legislative council and the formation of legislative council and alteration of the boundaries of the states. And what about the special majority? Special majority required two-third majority. Two-third majority. In the both houses, it required two-third majority individually. That means there are two houses, bicameralism. Parliament alone enjoy the power of the amendment of the constitution. We enjoy the power to amend the constitution. Parliament of India. Parliament of India enjoyed the power to amend the constitution of India under the article 386. So here there are both houses in parliament, upper house, lower house, Rajya Sabha, Lok Sabha. Both houses having powers to amend the constitution of India. Here two-third majority. What are the important provisions to amend the constitution under special majority? Fundamental rights. Fundamental rights also undercomes two-third majority. That means while amending the fundamental rights, it requires two-third majority. At the same time, direct to principles of state policy. Direct to principles of state policy also require two-third majority. Fundamental rights require two-third majority. Direct to principles also require two-third majority. And remaining provisions which are not undercome simple majority and special majority with 50% states ratification. Okay. So then what about the third category of the amendment procedure? Here the provisions regarding to the federal nature. What are they? Federal nature. The provisions which are regarding to the federal nature undercomes special requirement, that means special majority with 50% of states ratification. For example, union state relations, union state relations. For example, the Supreme Court. For example, the union government powers and functions. Under comes special majority along with 50% of the states should approve the bill. So this is the method of the amendment procedure which are mentioned in our Constitution of India. Whereas our Constitution Article 386 did not consider simple majority as amendment procedure. Originally, the Constitution of India did not consider simple majority as amendment procedure because by this simple majority, the provisions can change as common law, as normal law, ordinary law. Whereas these are the not ordinary laws, these are the special laws. These requires the two-third majority. For changing these provisions, it requires two-third majority. So that is why you have to mention our Constitution of India. Some provisions are amended in flexible manner. Some provisions are amended in rigid manner. Understood? So this is the one of the salient feature of Indian Constitution, that is combination of rigidity and flexibility. Understood? So because here we have the rigid features as well as flexible features. Then the next one is that combination of federal and unitary. Combination of federal and unitary. So Indian Constitution is considered as both the federal features as well as unitary features. Let us try to understand very clear manner. The fifth one is that combination of federal and unitary. Combination of federal and unitary. So what is mean by federal government? What is mean by unitary government? Keep in mind, all of you. Article 1 of the Indian Constitution. Article 1 of the Indian Constitution said Indian is the union of state. India is union of state. That means India is the combination of states. Here we are not used the term federal. So we never found the federal word in our Indian Constitution. Instead of the federal, we used union of states. Understood? So that's why we have to understand we are not incorporated the term federal, but we adapted federal form of government. Okay? Then here very clear, the term federal is derived from the Latin word feudus, which means treaty or agreement. Okay, so this federal feature incorporated with the inspiration of 1935 Government of India Act, at the same time with the inspiration of Canadian model, at the same time with the inspiration of American model. So basically there are different dimensions in the federal features. Finally we concluded our federal government is closely related to the Canadian model of federal government. Canadian model of federal government, because here the federal government, the basic feature of the federal government is division of powers. Division of powers. Powers are divided between union government and state government. Union government and state government. You know very well, 7th schedule divided entire the powers into the 3 lists. That was union list, state list, concurrent list. Union list, state list, concurrent list. Here the powers are divided. On the union list, the union government enjoy the powers. On the state list, state government enjoy the powers. On the concurrent list, both the union and state enjoy the powers. Okay, that's why here the division of powers are existed in India. At the same time, 2 governments, nothing but 2 governments. Is there 2 governments? Union government, state government. There is a bicameralism. There is a bicameralism. 2 houses. The legislature which contains 2 houses. Upper house, lower house. You know that Parliament of India contains 2 houses. Upper house Rajya Sabha, lower house Lok Sabha. There is a bicameral system. And also independence of judiciary. Independence of judiciary. So this is also one of the federal features. Like this, in Indian Constitution, we have some federal features. That's why India is considered as federal one. Besides the federal features, Indian Constitution also existed some of the unitary features. What are the unitary features of Indian Constitution? You know that one Constitution. Is there any Constitution for the states? No, there is only one Constitution for the both states and union government. And at the same time, strong center, the central government enjoys the more powers than state government. And also single citizenship. We enjoyed the single citizenship only, because unlike the USA, we enjoyed the single citizenship. Whereas in USA, there was a dual citizenship. The citizenship of the USA one, another the one is that the citizenship of the state concerned. Whereas in India, if you reside in Telangana also, you are having the citizenship of India only. There is no additional citizenship for the any people in India. Single citizenship, that is unitary government. That means unitary government is the government which is the one. Uni means one, tari means rule. Uni means one, tari means rule. Rule by one. That is called unitary government. The features of unitary government is one constitution, strong center, at the same time single citizenship, At the same time, election system, one election commission, appointment of the governors, appointment of governors. Governors are appointed by the President of India. President of India is the undercomes central government, but the governors worked in state government. Here the governor is the head of the state, but he is appointed by the central government. Is it undercomes unitary feature or not? At the same time, all India services, all India services, all India services. There are three all India services. One is IAS, Indian Administrative Service. Another one is IPS, Indian Police Service. And finally, Indian Forest Service, Indian Forest Service, not Foreign Service. These three are the all India services. They are appointed by the President of India, but they worked in the states. That is why the appointment of the all India services, appointment of the governor, election commission, single citizenship, integrated judiciary, they all undercomes unitary features. That's why our Constitution of India consists both the unitary features as well as federal features. That's why you have to remember Ambedkar's statement regarding to the federal and unitary form of government. Dr. B.R. Ambedkar, who is the father of Indian Constitution, who was the chief architect of the Indian Constitution, stated that India is the federal as well as unitary government. In ordinary time, India is the federal government. In emergency time, India became unitary government. You know very well K.C. Ware. Who is the one? K.C. Ware, popular constitutionalist. He described about the Indian Constitution is quasi-federal. That means of federal features, of unitary features. That means federal in form, unitary in spirit. Federal in form, unitary in spirit, according to the K.C. Ware. And also Ivor Jennings. Ivor Jennings, one of the famous constitutionalist from the Britain, he also described Indian Constitution is the federal form of government with centralizing tendency. That means unitary government which enjoyed the powers by one government. There is no division of powers in unitary form of government. According to Ivor Jennings, India is the federal form of government, but there is a centralizing tendency. Like this, Indian Constitution is the blend of both federal features as well as unitary features. It is the combination of federal as well as unitary. Understood? So this is the one salient feature of Indian Constitution. Then the next one is that parliamentary form of government. The sixth one is that parliamentary form of government. Parliamentary form of government. Keep it in mind. Don't concentrate on writing. You have to concentrate on my words. Okay. The parliamentary form of government. Here the another salient feature of the parliamentary form of government. Another feature of Indian Constitution is that parliamentary form of government. India adopted parliamentary form of government, which is inspired by the British type of. That means Westminster model of the government. British parliamentary system is popularly known as Westminster form of government. You know very well, Britain is the mother of the parliamentary system because the first parliamentary system originated in the Britain. That's why we are taken parliamentary system from the Britain and incorporated in India, both the union level at the same time state level. We are inspired by the British government and incorporated parliamentary system both the union level as well as state level. What is mean by parliamentary form of government? The government which is derived from the parliament. For example, if you take parliament, this is called parliament. For example, there are both houses, Lok Sabha, Rajya Sabha. The government which is headed by Prime Minister and the Council of Ministers, they all are comes from parliament only. Prime Minister is the member of parliament. Council of Ministers also member of the parliament. If the government is derived from the parliament, is called as parliamentary form of government. So here the parliament has control over the executive. That means here the government which is called executive, which is called legislature. That means here the government which is derived from the legislature and the parliament, nothing but the legislature, have control on executive. There was a responsibility. Understood? Here who responsible to the whom? Executive responsible to the legislature. That means government responsible to the parliament. That is why parliamentary form of government also called as responsible form of government. We accepted parliamentary system of the Britain, but we are not accepted the hereditary head of the Britain. The British parliamentary system headed by Queen or King, whereas we are not accepted such a hereditary head of the nation. We changed the provision that was elected head. Our head of the nation comes from the election manner. And moreover, the additional features is that two heads. One is nominal head, another one is real head. Nominal head, real head. The parliamentary form of government, the basic feature is that nominal head, real head. Who is the nominal head? In England, Queen or King. In India, President of India. Whereas in real head, in England, Prime Minister of Britain or England. In India, Prime Minister of India. That means the parliamentary form of government having the feature is two heads. One is head of the nation, that was nominal head. Another one is head of the government as real head. At the same time, responsibility, that means responsibility, collective responsibility. Collective responsibility also one of the feature of parliamentary form of government. Here the government collectively responsible, that means executive. The executive collective responsible to the parliament, that means legislature. Understood? There was a feature, the government, here the Prime Minister, Council of Ministers, collectively responsible to the parliament for their actions, for their omission and commission. They collectively responsible to the legislature, nothing but the Parliament of India in India. That's why there was a collective responsibility in the parliamentary form of government. Then, and also control over the executive. Control over the executive. Here who control over the executive? Legislature control over the executive. So they are asking the questions to the Prime Minister and the Council of Ministers in the Parliament of India. They imposed some motions like cut motions and also no confidence motion, like that. The legislature control over the executive. These are the features of parliamentary form of government. We adapted this in the union level as well as state level. So that's why this was inspired by whom? British type of Westminster model of the parliamentary system. Fundamental rights. Very important provision of the Indian Constitution. Fundamental rights are the rights, those are fundamental in nature. That means without these rights, the individual cannot enjoy his life. For making the individual life beautiful, these rights are essential. That's why they are the basic, they are the fundamental in nature. So you know very well, the fundamental rights are taken from USA Constitution, United States of America. In the United States of America, the fundamental rights are called as Bill of Rights. Bill of Rights. We are inspired the American model of Bill of Rights and incorporated fundamental rights in the Part 3 of Indian Constitution. Part 3. Part 3 of Indian Constitution from Article 12 to 35. 12 to 35. Originally, there are 7 fundamental rights. Original Constitution having how many fundamental rights? 7 fundamental rights. Whereas later on one was deleted. Now they became 6 fundamental rights. The deleted one is that right to property. Right to property, which is undercomes Article 31. Article 31, which is deleted from the list of fundamental rights, not by the from the Constitution of India. Keep in mind, the right to property, fundamental right deleted from the list of fundamental rights, not deleted from the Constitution of India, because this was deleted from the list of fundamental rights by the 44th Constitutional Amendment Act in the year 1978 and incorporated in the Part 12th of the Indian Constitution, 12th part, under Article 300A as legal right. As legal right. This is very important point. You have to note it down. Originally, the fundamental rights are 7 in number. In the year 1978, by the 44 Constitutional Amendment Act, one fundamental right, that is right to property, Article 31, deleted from the list of fundamental rights and incorporated in the Part 12 under 300A article, 300A article as legal right. As legal right. Keep in mind. Then what are the remaining 6 fundamental rights? You know very well. The first fundamental right is that right to equality. Right to equality, which is undercomes Article 14 to 18. Article 14 to 18. And the second right is that right to freedom, which is Article 19 to 22. And third one is that right against exploitation. Right against exploitation. Article 23 and 24. 23 and 24. And fourth one is that right to religion. Right to religion under Article 25 to 28. 25 to 28. And fifth one is that cultural and educational rights. Cultural and educational rights. Under which article? Article 29 and 30. Article 29 and 30. 31 article was deleted, that is right to property. Then finally, very important article is that right to constitutional remedies. Right to constitutional remedies. Under Article 32. These are the 6 fundamental rights which are existed at present in the Part 3 of Indian Constitution. What are they? Right to equality, right to freedom, right against exploitation, right to religion, cultural and educational rights, and then finally right to constitutional remedies. So you have to mention in the clear form, in the same order you have to mention while you are discussing about, while you are making the answer, you have to mention the same order. This is the order. right to equality started with Article 14, 18. So by this fundamental rights, the people enjoyed the rights against the legislature, against the executive. That means here the people enjoyed the freedom against the legislative activities, against the executive activity. For a while making the laws against the fundamental rights, we approached to the Supreme Court under Article 32. At the time, Supreme Court imposed some writ petitions. Understood? If any violation of our fundamental right, we have the right to approach. We have to approach to the Constitution of India, Article 32. Article 32, at the time, the Supreme Court proclaimed or imposed some writ petitions such as the habeas corpus, mandamus, certiorari, quo warranto. These are the 5 writs we will discuss later on in the fundamental rights chapter. Understood? That's why the fundamental rights are justiciable in nature. Fundamental rights are justiciable in nature. Because while fundamental rights are violated by any legislative activity or executive activity, the judiciary can protect our fundamental rights. That's why they are justiciable in nature. This is also one of the important salient feature of Indian Constitution. We inspired the Bill of Rights and also we inspired the 1948 Universal Declaration of Human Rights by United Nations General Assembly. We also inspired from that. Whereas we incorporated this much of clarity of fundamental rights in Part 3 of Indian Constitution. We never seen this type of classification in other constitutions. That is the peculiarity of Indian Constitution. Clear? Then the next one is that directive principles of state policy. Directive principles of state policy also considered as one of the salient features. At the time of making of the Constitution, the Constituent Assembly formulated one advisory committee under the leadership of Vallabhbhai Patel. This committee was again divided into subcommittees. That subcommittee chaired by J.B. Kripalani regarding to the fundamental rights. That committee classified rights are 2 types. One is justiciable, another one is unjusticiable or non-justiciable. The fundamental rights are justiciable, whereas the directive principles of state policy, directive principles of state policy, DPSP, directive principles of state policy are non-justiciable, non-justiciable. Understood? Directive principles of state policy are non-justiciable. They are also rights. Here the rights to whom they are the directions. Listen, keep it in mind. Directive principles of state policy are the directions given by the Constitution to the state of India for making policies. For making policies. Directive principles. To whom? State. For what? For making policies. That is the definition, that is the meaning of directive principles of state policy. Here, the Constitution of India gave some guidelines to formulate policies, nothing but the welfare policies to the government of India, state of India. So they undercome directive principles of state policy. We have been taken from Ireland Constitution. Directive principles of state policy taken from Ireland Constitution and incorporated in Part 4 of Indian Constitution from Article 36 to 51. Keep in mind, directive principles of the state policy have been taken from Ireland Constitution or Irish Constitution, incorporated in our Constitution in the Part 4 from Article 36 to 51. Article 36 to 51, there are some directive principles. They are the directives to the government of India for making welfare schemes, welfare policies. These directive principles are classified into three different forms. Directive principles are classified into three categories. One is socialistic principles. Socialistic principles. Another one is Gandhian principle. And third one is the liberal principles. Liberal and intellectuals. Intellectual, liberal and intellectual principle. So they are the three categories under directive principles of state policy. So here by the socialistic principles, the principles regarding to the convert India into a socialist country. India into a socialistic country. For example, distribution of wealth, elimination of inequalities, understand, and providing the equal pay for equal work, and providing the work to the citizens of India, and also promote the health, and also provide the nutrition. Under comes socialistic principles. That means according to the directive principles under socialistic principles, the Constitution of India gave some guidelines. Says India how converted as socialistic country. If the India provide these following directive principles, India became socialistic country. These are the directives which are given by the Constitution to the Government of India, State of India. And Gandhian principles, when you observe the Gandhian principles, they are inspired by the Gandhian ideology. One is implementation of Panchayat Raj, and also promotion of the cottage industries, providing the education, particularly the weaker sections. Like this, the Gandhian principles also undercomes directive principles of state policy. They are inspired by the Gandhian ideology. Liberal and intellectual principles, they also undercomes. For example, if you take example regarding to the environment and regarding to the extending our help to the United Nations organization, and also separation of the judiciary from the executive, they undercomes liberal intellectual principles. Here, the directive principles of state policy also considered as one salient feature of Indian Constitution, which are inspired by the Ireland Constitution. In Ireland, they are called as social principles of state policy. That's why these are the directive principles of the state policy. They are classified into three categories: socialistic principles, Gandhian principles, liberal and intellectual principles. Here, according to the Ambedkar, directive principles of state policy are novel practice, novel features. Who said directive principles as novel features? Novel features means they are the innovative, new features which are never seen in other constitutions. This was given by whom? Dr. B.R. Ambedkar. Ambedkar said that directive principles of the state policy as novel features, new features, innovative features. At the same time, the Constitution of India specially mentioned about the directive principles. They are the very important principles which are must implemented by the government, because if the government is neglected, the India unable to considered as welfare state. And moreover, in the Minerva Mills case 1980, the Supreme Court described both the fundamental rights and directive principles are treated equal weightage. There is a equal weightage because fundamental rights are justiciable in nature, directive principles are non-justiciable in nature. Because here if the government is not implemented the directive principles, we are unable to approach to the judiciary because they are non-justiciable in nature. Whereas in Minerva Mills case 1980, the Supreme Court of India described both the fundamental rights and the directive principles of state policy are treated equal weightage. So this is about the salient feature of directive principles of state policy. Then the next one is that fundamental duties. Fundamental duties. You know very well. Is there fundamental duties in original constitution? No. In original constitution, there is no fundamental duties. Later on, we incorporated. Keep it in mind, all of you. Fundamental duties. Fundamental duties are not existed in original constitution. They are not existed in original constitution because this was the feature which are added later on. When we added to the Constitution of India in the year 1946, that means at the time of 1946, what happened in India? There was an internal emergency. The year 1945, Indira Gandhi government proclaimed internal emergency. At the time of internal emergency, the Indira Gandhi government appoint one committee, that was Swaran Singh committee. Which committee? Swaran Singh committee. Swaran Singh committee appointed by the Indira Gandhi government. This Swaran Singh committee recommended some of the fundamental rights to incorporate in the Indian constitution. That's why based on the Swaran Singh committee recommendations, we incorporated 10 fundamental duties. 10 fundamental duties by the 42nd Constitutional Amendment Act. Understood? Originally, there are no fundamental rights in our constitution, fundamental duties in our constitution. Whereas in the year 1946, we incorporated 10 fundamental duties to the Constitution of India on the recommendation of Swaran Singh committee, which is appointed by the Indira Gandhi government. So this Swaran Singh committee recommended 10 fundamental duties. They are incorporated in the part 4A. Part 4A and Article 51A. What is the location of the fundamental duties? Part 4A of Indian Constitution and Article 51A. It consists 10 fundamental duties. So that's why keep it in mind, all of you. Originally, there are no fundamental duties. Later on, we added 10 fundamental duties. Again, we added one more fundamental duty to the Part 4A of Indian Constitution by the Constitutional Amendment Act 86. 86 Constitutional Amendment Act. In the year 2002, we added one fundamental duty to the Part 4A of the Indian Constitution. Now, how many fundamental duties are there? 11 fundamental duties are there. At present, there are 11 fundamental duties in Part 4A of the Indian Constitution and Article 51A. So, why we are incorporated fundamental duties here? Actually, in original constitution, our constitutional makers did not expect the special mention of the fundamental duties because they thought Indians are responsible people. Whereas, they aware later on, Indians are not such a kind of responsible people. They must remembered by the government of India, by the Constitution of India regarding to their duties. Because here, rights given to whom? People. Rights are given to the people by constitution, that means state. For that we should give some of the duties to the state. State gave some rights to the citizens. For that we should give some responsibilities to the state. Towards the state we should respect, we should give some responsibilities. Duty is nothing but responsibility. That's why we inspired from the Russian constitution, nothing but USSR. Previously it was called as USSR constitution. Now it was called as Russian constitution. From the Russian constitution we have been taken fundamental duties and incorporated in the part 4A of the Indian constitution under article 51A. So the state which expected some responsibilities from the citizen of India. What are the responsibility? Respect our constitution, respect our nation, respect our national flag, and also promote the sovereignty and also integrity, promote the unity and integrity among the people, respect the women. Like this, there are some fundamental duties in our constitution of India, which are taken from which constitution? Russian one, and also which suggested by Swaran Singh committee. So these are the fundamental duties. We will discuss very clear in fundamental duties topic. Then the next one is that bicameralism. Bicameralism, you know very well, already we studied the first year. Bicameralism, the 9th provision is that bicameralism. What is meant by bicameralism? Bicameralism means the legislature which consists two houses, upper house, lower house. Upper house, lower house. The legislature which contains two houses, upper house, lower house. Here upper house, for example, if we take Indian legislature, considered as Parliament of India. Parliament of India. In the Parliament of India, there was a bicameral system. Two houses are there, upper house, lower house. In Parliament, upper house is called as Rajya Sabha. Rajya Sabha. Lower house is called as Lok Sabha. Understood? In our Indian parliamentary system, we adapted bicameral system, which inspired by the British model, at the same time USA model. You know very well, the bicameral system which is taken from Britain model, at the same time USA model. Whereas for the first time in India, that bicameral system introduced by 1919 Government of India Act. By the Government of India Act 1919, we introduced bicameral system in India for the first time at which level? Union level, central level. Whereas this was extended to the states, the bicameral system extended to the state by the 1935 Act to the provincial level. Provincial level also. That means there was a bicameral system at union level as well as provincial level, state level in India. But the Constitution of India gave relaxation to the states. That means gave the choice to adapt the bicameral system to the states. If the states are interested, they may adapt bicameral system. Otherwise, they may continue as unicameralism. So keep in mind, in the bicameral system, the legislature which contains upper house, lower house. In Indian point of view, upper house is nothing but the Rajya Sabha, which is representing to the states, and the members of the Rajya Sabha comes from states only. It was not represented to the people. It represented to the states. Whereas the Lok Sabha, which is lower house, here keep in mind, Lower house, Lok Sabha. It's easy to remember. This represents directly to the people. It is the people's house. It was Rajya Sabha called as Council of States. Lok Sabha called as House of People. People's house. House of People. Because Lok Sabha represents to the people directly. The members of the Lok Sabha comes from the people directly. That's why we adapted bicameral system in the union level. Whereas at the state level, the constitution gave the choice to the states regarding to the adoption of bicameral system. When you observe the present scenario, India consists 28 states after the Jammu Kashmir incorporation. There are 28 states at the same time 8 union territories. Here, out of the 28 states, how many states are having bicameral system? You have to remember there are 6 states. There are 6 states are enjoyed bicameral system. They followed bicameral system. Out of the 28 states, 6 states are followed bicameral system.